Kalorama, a recorded books/Highbridge imprint, presents Pardon Power, How the Pardon System Works and Why, by Kim Wehle. Read by Holly Adams. Foreword by John W. Dean. On April 25, 2024, the U.S. Supreme Court heard oral arguments in Donald J. Trump v. United States, an appeal from an indictment charging the former president with 4 federal felonies arising from the January 6, 2021 insurrection at the U.S. Capitol. The story is well known. A mob of Trump's supporters violently stormed the Capitol building to disrupt a joint session of Congress while counting the Electoral College votes to formalize the election of Joe Biden as President of the United States. The goal of the mob was to stop that process, so their defeated candidate, Donald Trump, could illegitimately remain in the White House. Trump's appeal to the High Court sought to stall this criminal case, as he had done with the 3 other criminal cases he faces, employing any and all tactics to delay conviction before the 2024 election, when he hopes he might find a way back to the White House and the temporary immunity enjoyed by all presidents during their time in office. Mostly as a political ploy, Trump's appeal claimed that he and all presidents should have permanent immunity from criminal charges, both while in office and after. In short, to tie up his case, Trump was claiming what no other president had ever claimed: that presidents are above the law. Thus, the question before the court is whether the indictment must be tossed out as a matter of constitutional law after the lower federal trial court and Court of Appeals for the District of Columbia rejected this novel claim. That the U.S. Supreme Court did not summarily reject Trump's appeal and is giving it serious attention speaks to the radicalism that surrounds Trump and to the fact that he nominated 3 of the justices who are now considering his call for criminal immunity. We await the answer as I write. To date, over 1,200 people have been arrested and charged with offenses relating to the events of January 6, 2021. More than 460 have been sentenced to prison. Trump's argument that he, and he alone, should be immune from any legal accountability whatsoever for his role in the January 6th carnage, along with his multifaceted scheme to remain in office, were facts with which the conservative justices showed little interest. Rather, as Justice Neil Gorsuch stated during the argument, the controlling conservative majority appeared most interested in writing a rule for the ages. As Republicans have found it increasingly difficult to win electoral majorities and consistently control Congress, they have focused on packing the federal courts with conservative judges and justices and expanding presidential powers. Trump has given the Supreme Court a case that should be used to strengthen democracy by checking presidential powers. Instead, the conservative majority appears to see it as an opportunity to vastly expand presidential power rather than constrain it, by placing the president above the law, both civil law, which Nixon accomplished in 1982 after his presidency, by prompting the court to establish civil immunity for presidents in Fitzgerald versus Nixon, and now criminal law. This potential landmark case is relevant because pardon power, the subject of this book, arose at least 13 times during the argument, and presidential immunity from criminal prosecution is closely associated with the unresolved matter of presidential self-pardons. Trump claims he could have pardoned himself, notwithstanding the fact that no president has ever done so, nor, save for Nixon, needed to do so. Others never considered it, I suspect, because, as Nixon was told, self-pardons are contrary to the reality that no one can fairly judge their own case. The pardon power surely will influence the resolution of this presidential immunity case. Accordingly, the High Court had questions about the president whom I served as White House counsel, Richard Nixon. Justice Ketanji Brown Jackson asked Trump's lawyer, "What was up with the pardon for President Nixon? I mean, if everybody thought that presidents couldn't be prosecuted, then what was that about?" He responded incorrectly Well, he was under investigation for both private and public conduct at the time, official acts and private conduct. The conservative justices showed great interest for the idea of creating a dividing line between private conduct by presidents that could be prosecuted and public conduct that cannot, even though it's the public side that invites severe abuses of power. Justice Gorsuch noted in an exchange with Trump's attorney, and then the question becomes, as we've been exploring here today a little bit, about how to segregate private from official conduct that may or may not enjoy some immunity. Nixon, like Trump, did bad things, this line of inquiry went. But only some of those bad things can give rise to criminal prosecution, even after a president becomes a private citizen. By the time this book is published, we will have the Supreme Court's answer on criminal immunity for presidents. Questioning by the conservative justices suggested they may establish a radical new standard for the American presidency, making some criminal conduct by the U.S. Commander-in-Chief above the law. This will mean that by brazenly breaking the law, Trump will have managed to persuade these potential enablers to distort the Constitution to insulate not only his behavior, but that of future presidents from legal accountability for lawbreaking. This is beyond ironic for me, not to mention a serious threat to our democracy. As someone who served under Nixon from July 1970 until he fired me in April 1973, I can say with confidence that Trump's attorney is wrong about Nixon's abuses of power and the criminal conduct that forced his resignation. Everything Nixon did in connection with the so-called Watergate scandal would qualify as official presidential conduct that could now be immune from prosecution if the court rules as some justices appeared inclined to do. As counsel for the government, Michael Dreeben explained in response to a question from Justice Samuel Alito, the Watergate smoking gun tape involved President Nixon and Chief of Staff H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation. Managing the Central Intelligence Agency, an entity lodged at the apex of Article II power to execute the law, is quintessentially official presidential conduct. Staving off its abuse is why we have legal and constitutional guardrails. I understand this well. As the person who warned Nixon that his behavior was a cancer on the presidency and blew the whistle on his abuses of power, I know the criminal law is a powerful deterrent on the White House. Justice Gorsuch raised a concern that the pardon power could be routinely abused by presidents if they aren't given criminal immunity. Never mind that in our 236-year history, this problem has never materialized. What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office? Gorsuch asked. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Without criminal immunity to keep them above the law, in other words, presidents would try to put themselves above the law every 4 years from now on. So why not give presidents a permanent, preemptive pardon now, under the guise of criminal immunity? Justice Alito later raised the identical point. Although the hypothetical is somewhat tortured, his concern that presidents can use the pardon power to commit or cover up crimes is a real one. To make the point, Nixon dangled pardons throughout Watergate as a means of accomplishing the cover-up on criminal activity, and this book illuminates other such situations. It is high irony that Justices Gorsuch and Alito suggested the possibility of a self-pardon to justify immunizing presidents from accountability for crimes. As will be learned from the following chapters, the pardon power is an arcane vestige of an unlimited monarchy under which the divine right of kings, the belief that God selectively mandated the ruler's power and legitimacy, prevailed. Whether that view will retake hold in the 21st century under a constitutional democracy established to reject that very model may prove to be the greatest American political crisis of the age. Because of that sad reality, this book could hardly be timelier or more important. I was involved in one of the historic pardons recounted in this book, a pardon some believe was orchestrated by President Nixon as a quid pro quo for votes in the 1972 election. On December 23, 1971, Nixon commuted the sentence of Jimmy Hoffa, the former head of the International Brotherhood of Teamsters, who was serving an aggregate of 13 years for jury tampering, attempted bribery, conspiracy, and mail and wire fraud after 2 separate trials. When John F. Kennedy took office in 1961, his brother, Attorney General Robert Kennedy, made it a priority to pursue Hoffa, who was widely suspected of involvement in organized crime and spearheaded what the press called the Get Hoffa Squad within the Justice Department. The first Hoffa trial took place in Nashville, Tennessee in 1962. The indictment alleged that Hoffa accepted $1 million from a trucking company to keep the peace among union members. That case ended in a hung jury. 2 years later, Hoffa was tried and convicted in Chattanooga for tampering with the Nashville jury. And in June of 1963, he was indicted and convicted by a jury again in a federal court in Chicago on charges of mail fraud, wire fraud, and conspiracy stemming from a $25 million scheme to defraud a union pension fund. Hoffa was barely 5 years into his 13-year sentence when Nixon pardoned him. The Teamsters subsequently endorsed Nixon in his re-election bid in 1972, despite its long record of supporting Democrats almost exclusively. Critics charged that Nixon pardoned Hoffa to win the union's favor and attract members to the Republican Party. A New York Times story from March 17, 1974, declared that although the political base upon which President Nixon built his landslide re-election victory in 1972 is melting away like a sandcastle before an incoming tide, one block of his base at least has remained almost touchingly steadfast to the president, the International Brotherhood of Teamsters, the nation's biggest trade union, and its president, Frank E. Fitzsimmons. As this book explains, there's not much law constraining presidents' power to use pardons for personal gain. In 1974, like today, the public barely notices when presidents do abuse the pardon power, so it has increasingly become common practice. Nixon's commutation of Hoffa came with a condition, however. To get out of prison, Hoffa could not engage in the direct or indirect management of any labor organization until March 6, 1980. There was speculation that Nixon made this conditional at the request of Frank Fitzsimmons, the new president of the Teamsters, in exchange for support in the election. Fitzsimmons denied it. After his release, Hoffa was determined to return to union leadership. He sued to invalidate the condition attached to the pardon, claiming it was unconstitutional and formulated and imposed as the result of a conspiracy involving the president. Hoffa lost the case, as described in the chapters that follow. Claiming that the condition was imposed in return for political favors from Fitzsimmons, Hoffa wanted the condition removed from his commutation. He also claimed that there was no historical precedent for attaching conditions to pardons. Not so. I sat for a deposition in Hoffa's lawsuit, Hoffa versus Saxby, because I came up with the idea of Hoffa's conditional pardon. Hoffa's lawyers subpoenaed documents related to the clemency decision, including memoranda by me to Nixon and his Attorney General, John Mitchell, but the judge quashed the request on the grounds of executive privilege. Although Hoffa appealed, the case became moot when he disappeared on July 30, 1975. He was later declared dead. To this day, it's widely believed that I drafted the conditional pardon at Nixon's direction. as part of his bid to get Fitzsimmons behind his re-election. That's not what happened, however. A week or so before Hoffa's pardon, which was signed 2 days before Christmas in 1971, I was walking from the Executive Office building office to the West Wing of the White House and ran into Mitchell, who had just come from a meeting with the president. Because pardons were processed through my office as a final review before going to the president after coming from the office of the pardon attorney in the Justice Department, Mitchell told me that they were going to pardon Hoffa. There had been newspaper speculation that Nixon might do this, so I was not totally surprised. But I was also aware that the Department of Justice was concerned about Hoffa's ties to organized crime. When talking to Mitchell outside the West Wing that December 1971 afternoon, it occurred to me that the government might want to keep Hoffa out of the union business. I asked Mitchell, who had been my boss at the Justice Department before coming to the White House, if they were going to issue a conditional commutation. He had no idea what I was talking about, or that Hoffa could be prevented from union activities in exchange for his release from prison. I explained that I had read that Abraham Lincoln, as president, had issued pardons after the Civil War that came with conditions. When I recently shared this story with the author of this book, she reported that research revealed that on March 11, 1865, Lincoln offered a pardon to deserters of the Union Army on condition that they return to their regiments and companies or to such other organizations as they may be assigned to and serve the remainder of their original terms of enlistment, and in addition thereto, a period equal to the time lost by desertion. Anyway, Mitchell liked the idea and requested I draft some language and send it over to him, which was done. I can still see the expression on Hoffa's face when he deposed me, and the disappointment also of his lawyers. They thought this was surely a sinister plot, long in the making, and not the happenstance that actually occurred. While I was White House counsel, in this instance, I had merely been a staff man, making sure my superiors had what they needed, and, in fact, they did want to keep Hoffa out of union affairs, albeit out of prison for political reasons. I heard no talk of quid pro quo. The Watergate scandal has been routinely resurrected during the Trump years, but looking back, there is no comparison of these men or their presidencies. Richard Nixon's abuses of power do not come close to those of Donald Trump, conduct which the Supreme Court appears poised to insulate, at least partially, from legal accountability. A few salient comparisons of these men. I am not known as a Nixon defender, but I cannot envision Richard Nixon having a sexual encounter with a porn star, nor an extended affair with a Playboy playmate. Nor did Nixon ever disrupt the transition of government power. When Nixon lost the 1960 presidential election to John Kennedy, notwithstanding serious irregularities in the Illinois returns, he conceded. Rather than put the nation through the agony of an impeachment trial for Watergate, he resigned. Nixon was an establishmentarian, not to mention a man with a conscience. Trump is neither. Let us hope we are all mistaken in interpreting the justices' questions, and they do not give Trump the pass he seeks. Staging a coup to steal an election from a legitimate president is the essence of tyranny. Moreover, today there's a greater need to use the legal system to rein in presidential misconduct than in the 1970s, when Americans relied on trusted news sources for their information, outlets like the New York Times, the Washington Post, CBS, ABC, and NBC. People made voting decisions based on a uniform set of facts. Nixon left office at the Republican Party's insistence because he had lost public trust. That's nearly impossible now. Nixon lost support and his presidency because the American people shared a common narrative that exposed him as a danger to the country. Today, while Trump piles on his endless lies, the modern Republican Party has redesigned itself to embrace his blatant dishonesty. Donald Trump has made the pardon power an issue every American should understand. If he fails to win in November, he will need pardons for himself, both state and federal, for he will be convicted in one or more of the 4 cases, with 88 felonies total. But should he prevail, he will abuse the pardon power as no president ever has, an inescapable conclusion from his first term and his very nature. From the following, you can better appreciate how this will unravel our democracy. May 2024. John W. Dean, Counsel to the President of the United States, 1970 to 73. The Nixon White House. It is better that 10 guilty persons escape than that 1 innocent suffer. William Blackstone. As has been stated by numerous legal scholars, I have the absolute right to pardon myself, but why would I do that when I have done nothing wrong? Donald J. Trump. I will tell you, I will look very, very favorably about full pardons for January 6th, 2021. If I decide to run and if I win, I will be looking very, very strongly about pardons, full pardons. We'll be looking very, very seriously at full pardons because we can't let that happen. And I mean full pardons with an apology to many. Donald J. Trump. It was an awesome, ultimate power over the lives of others that no person or government should have or crave. Pat Brown, former governor of California. Introduction. From 1959 to 1967, Edmund G. Pat Brown served 2 terms as governor of the state of California. During that time, he received 59 petitions from death row prisoners urging him to halt their executions and commute their death sentences to life in prison. In 36 cases, Brown denied the requests, and the prisoners were put to death. The remaining 23 petitioners lived at Brown's sole discretion. By the time he moved into the California governor's office, Brown knew a few things about the criminal justice system. He had already served 7 years as the San Francisco district attorney and 8 years as California's attorney general. He understood that the public he served demanded victims' justice and public safety, and that the state legislature had enacted laws allowing for capital punishment. But he also knew that the criminal justice system is not a one-size-fits-all proposition. Each case is different. Death row inmates are mostly male, largely uneducated, and primarily Black or Hispanic. Many have personal and family histories of child abuse, mental health issues, and addiction. In a book about his wrenching decisions to bestow life or compel death on what he called the worst members of our society, Brown described his role as not the decider of guilt or innocence, or of the finer points of the law. He was certain that everyone he considered for commutation was guilty of the brutal crimes involved. He instead sought to look for some extraordinary reason why the defendant should not be executed, a legal or moral reason to go against the judgment of the court. By Brown's account, he sometimes got the calculus right, but he also got it wrong. The story of John Russell Crooker, Jr., who murdered his former lover with a kitchen knife in a crime of passion, ended well. Crooker confessed. He appealed his conviction all the way to the U.S. Supreme Court, but failed to persuade the justices that his confession was coerced. Governor Brown decided, nonetheless, to commute Crooker's death sentence to life in prison. After considering his psychological problems, difficult family history, the absence of premeditation or a concealed weapon, and his potential for rehabilitation, Crooker was eventually paroled and went on to lead a decent life. Simon Wien's story ended differently. He was convicted of a series of sexual assaults, robberies, and kidnappings, and was sentenced to death. Wien had no prior felony convictions and was a docile inmate. Brown commuted his sentence to life. Wein was later paroled and went on to murder someone. And why? One pardoned prisoner lives a model life, while another goes on to murder someone. Does this comparison say anything about the goals behind the power to pardon? The contrast between Wein and Crooker is especially notable because they knew each other in prison. After Wein's release, Governor Brown met with Crooker. During the meeting, Crooker told the governor that he wished he had warned him not to commute Wein's sentence. The other prisoners knew Wein was dangerous. Brown later reflected on his conversation with Crooker. Crooker's comments stunned me into rare silence. The implications were at once obviously simple and subtly ironic. Here was a man whose life I had spared at least in part because of his intelligence and future potential, now out of prison and leading a useful life, telling me that he and other prisoners turned out to be better judges of the inner nature of another man whose life I'd spared, better judges than a governor, several psychiatrists, and a host of other skilled professionals. Yet commuting Wein's sentence was not Governor Brown's most regrettable clemency decision. His decision to deny Richard Arlen Lindsay's petition haunted him even more. Lindsay was convicted of raping and murdering a small child and sentenced to death. Like the others, Lindsay had severe mental health issues and a troubled childhood. Governor Brown reported that he couldn't for the life of me see how killing Lindsay would keep another madman from attacking another little girl somewhere down the road. He nonetheless denied Lindsay's petition for political reasons. Brown was seeking to get a farm labor bill passed, and the deciding vote came from a legislator whose voters lived in the county where Lindsay committed his crime. The governor declined to spare Lindsay's life so he could get a minimum wage passed for farm workers. In the American system of government, which hinges on a functioning representative democracy and where politicians derive their power from the people and are accountable to the people, there is a gaping level of unconstrained power, the power to pardon. It is inherently inconsistent with democracy, vesting complete discretion and control in a single person to achieve fairness. And in theory, the pardon power is somehow supposed to operate without undermining the message sent by the original conviction and sentence. Don't try this, or you'll be held accountable too. At the federal level, presidents can issue pardons for federal crimes. At the state level, some governors can pardon state law crimes. Others share the power with boards or commissions. Governors pardon at much higher rates than presidents simply because there are many more state prosecutions than federal ones. Pardons also come in many varieties, spanning those that erase a criminal conviction altogether to those that erase only part of it while retaining other sorts of penalties, to those that only shorten or alter a sentence, a form of clemency known as commutation. For purposes of this book, the term pardon is treated as one-size-fits-all, encompassing terms like clemency and commutation as well. The reason is that the technicalities regarding the form of pardon are less important to the aim of the book than the ideas behind the act itself. 1. That a single person, who is overwhelmingly white and male, is better positioned to make life-altering judgments about an individual's culpability for a crime than the legislators, judges, and juries that rendered the judgment in the first place. And 2, that such a person will exercise that power with fairness and integrity, rather than out of bigotry, laziness, callousness, or self-interest. Pardons really make sense only if both of these conditions are satisfied. As this book will show, the better argument appears to be that neither one is. At their greatest height, pardons can wipe an individual's criminal record clean, unlock the prison doors, and put them back into society. In the normal course of the criminal justice system, in order for this to happen, that person would have to hire and pay lawyers to get them through months or years of fact-finding, legal analysis, hearings, trials, temporary incarceration, and appeals, all banking on the chance of an acquittal, a hung jury, a favorable plea, a shorter sentence.
Sample complete. Ready to continue?